But I want to make sure we've have time for our speaker. We have a guest with us today, Laura Evans from the Leitner Law Group. I think we'll continue the pattern of we'll let Laura present. And Laura, I'm not sure if you're familiar with Google Meet or not, but it looks like there's an option down in the lower right-hand corner. If you want to click on Present Now, you can share your slideshow when you're ready for that. If that doesn't work, we'll figure something out. But I'm grateful to everyone for their patience as we work through this, and are excited to get started. I'd like to offer a prayer and a few more words, and then we'll move into that session. God, we thank you for the gift of technology, and we thank you for the gift of flexibility to maneuver when technology doesn't do what we want it to do. Maybe in that way, technology is like life. Sometimes it doesn't go the way we hope and plan. And we pray that we may have the grace and the comfort of your peace to guide us through uncertain times. We're grateful today for Laura and her presentation about how to manage and live after death, especially as survivors and those who are picking up pieces and organizing our world. We thank you for your presence among us. It's in Christ's name we pray. Amen. Laura, I think if you want to unmute yourself.
Yes, okay. And this is my first time with Google Meet, so please bear with me.
You and me both. I think a lot of us.
All right, let's see. Let me just make sure that okay. So I want to make sure I can get the presentation. Also, bear with me. My Instacart order just got dropped off, so my kids are running it back and forth. It's just one of those mornings. So let's see. I think I'm ready. So I will go ahead and start.
Great.
Okay.
While you're looking at that, I'll just say a few more words. Laura is a peer of Dawn Ruppel, who's a member of our congregation, and Dawn gave us the recommendation of Laura. Laura is an attorney and counselor at law at Leitner Law Group in Harrisonburg, and so we are grateful to have your expertise and presence among us.
Thank you so much. Okay. And actually, Dawn was my first job as an attorney. She gave me my first job as an attorney. So I'm always thankful to her. She has been a mentor to me, and I adore her. Okay, so can everybody see my screen? I'm trying to figure out how I get it bigger. Let's see. Nope, that's not what I want to do. Again.
That doesn't look too bad, and I can still see you on the right side, and now that's too small.
Okay, let me see.
Be helpful.
Okay, let's see. Maybe this. No. What does this look like for everybody?
I can see it fine, Beverly.
Okay.
I think that's good. We'll go ahead and
all right.
what it looks like.
Okay, thank you so much for bearing with me. And again, thank you so much for having me. I really appreciate it. This is one of my passions, talking about estate planning and why it's so important, not just for you, but also for your family members. And so the title of this is Estate Planning, Peace of Mind for You and Your Family. And so I will just go ahead and get started. One of the first and most basic questions that people ask regarding their estate planning is, do I need a will? The answer to that is usually yes, and that it is especially true if you want to be able to determine who are going to receive your assets at your death, if you want to be able to designate who's going to administer your estate, and if you want to be able to designate who's going to handle any of your assets for any minor beneficiaries or for those beneficiaries that have special needs. What happens if I don't have a will? And this is often one of the most important questions to think about when you're trying to decide about that, because if you don't have a will, oftentimes it leaves a big mess for your loved ones at the end. Also, those people may receive your property that you don't want them to, and you don't have any control over who's going to be in charge of it. So if you don't have a will, the law in Virginia is that your spouse would receive it. But if you also have children that are not also your spouses, then your children would split 2/3 and your spouse would get 1/3. And then one of the things that I have listed on the slide is if you don't have a will, or if you do have a will and it doesn't waive bond, then your executor or administrator will have to post a bond with surety, which is very expensive and often costs several $1,000s a year. It's basically just ensuring that the executor administrator is going to do what they're supposed to do. When you're talking about a will and what is going to pass by way of a will, you are going to be talking about probate property. Probate property is what is going to pass according to the terms of your will, or by the laws of intestacy, which is what we just talked about, which is what would happen at your death if you did not have a will. Now, non-probate property is basically anything else that has a beneficiary designation. So this is typically going to be a retirement account where you designate, at my death, I want my spouse or whoever you name. Also, there are payable on death or transfer on death designations. Usually we see these on bank accounts or investment accounts. Also, if you own property, joint tenants with right of survivorship, that will automatically pass at death. And oftentimes, people will own different bank accounts and financial accounts, either with their spouse or as they age, they might add their adult children on there. Probate property, like I said, that is what is going to be controlled by your will, where you haven't designated where that's going to go. Okay. Now, the next question, a lot of people ask this, and this is a question we get often, is how do I change my will? You can revoke your will by a physical act such as burning, cutting, tearing, or obliterating, or you can execute a new will. You can amend your will with a codicil. And in addition, when we prepare a will for a client, we often reference a separate document for the disposition of the client's tangible personal property or his stuff and his digital devices, passwords, online accounts, etc. And you can change that separate document at any time without having to change your actual will. A lot of people want to know if they can just change their will themselves. I would not recommend it. I have seen horror stories in terms of that. People often think if they just write on their will and cross out different provisions that that's enough, or they might make notes in the margins. If we use any of those techniques could actually invalidate your will. I have just a story that I'll tell you how this can actually really hurt your estate plan. I have an executor that I represent where the person's will, he decided that he wanted to leave his children out of his will. He had originally stated in there that he wanted to give them each a certain amount of money. And what he did is he went ahead and just crossed those out. And the balance of his estate was supposed to go to his church, but instead, what that happened is it invalidated his will. And when he died, because it was invalidated, everything went to his kids, which was exactly what he did not want to happen. Another question we often get is, can I write my own will? The answer to that is absolutely, you can. One thing that people is often easiest, and what people will try to do, is do what's called a holographic will. And that is a will that is entirely in the person's handwriting. And unlike a will that is done by either that's typed, it does not have to be notarized. And there are also many commercial will kits out there or online, like LegalZoom or Trust in Will. You can even go to Staples and buy commercial will kits. I caution you about doing that, though, because what you may just think that you are doing what you need to do in terms of that, but you may not fully distribute your estate. Like I said earlier, you could forget to waive the bond, and then your executor would have to post bond with surety. And also, if you don't give your executor all the powers that they may need, such as selling real estate, those are specific powers that have to be named in the will. We urge you to seek out experienced estate planning counsel to help you with that. Now, okay, so that's screen. Okay, there we go. So what is a trust? This is another important estate planning tool that we often find is very misunderstood. A trust, first of all, is a fiduciary relationship in which one party, who's known as a grantor, gives another party, the trustee, the right to hold title to property or assets for the benefit of a third party, the beneficiary. So who are the parties to a trust? The settlor, grantor, or donor. These names are interchangeable, and this person is the owner who transfers the property into the trust. And so if you are the one creating a trust, this would be you. Beneficiaries are pretty self-explanatory. These are the people who are going to receive your property either during your life or at your death. And the trustee is the person who manages the property for your beneficiaries. There are two different types of trusts. A testamentary trust is a trust that is created with the terms of a person's will. And that is a trust that is created upon the death of the testator. An inter vivos trust, or more commonly called a living trust, is a trust that's created during the lifetime of the grantor. And there are two types of living trusts. There are revocable and irrevocable trusts. We recommend living trusts over testamentary trusts in most situations, except for a few very limited scenarios related to Medicaid benefits. Testamentary trusts are going to be required by your local commissioner of accounts to file annual accountings for every penny in and every penny out. This gets to be overly burdensome, especially if investment. Actually, let me just hold on one second. My children are literally killing each other. So hold on one second. I will be right back. I'm so sorry.
While she's away, we can take an opportunity to extend grace. It's something those of us with children and cats and dogs have all experienced in this beautiful time of Zoom and Google Meet. So I know she can't hear it, but we'll excuse this without any trouble at all, I'm sure. This is why I do Zoom meetings at the church. It saves the dog from barking. And for those of you that might be wondering what Instacart is, it's a shopping app that you can shop for and have things delivered for you. I had looked it up when she said my Instacart just dropped. So I did a quick Google.
Jeff, real quickly, will we be able to get all of her slides somewhere? In other words, her PowerPoint, will we be able to get a printed copy of that if we want it?
Absolutely. I can email that to you. I'm so sorry about that. My husband's not home, and they've just decided not to behave today.
No worries, Laura. It's all good.
I could hear them, and then I was like, okay, maybe they'll just stop, and then they just, yeah. So anyway, I will be happy to. At the end of the slide, there's going to be my email address. So if you want to email me, I'll send you a copy of it.
Great. Thank you.
Okay. So sorry about that. Getting back to this, we were talking about the difference between living trusts and testamentary trusts. And as I said, with the testamentary trust, one of the things with probate, which we talked about at the very beginning, is that the Commissioner of Accounts, who is in charge of basically making sure that an executor is doing what they're supposed to be doing, he's going to require with the testamentary trust an accounting each year that the testamentary trust is in effect. And the reporting requirements related to that can be actually very difficult. And we often get executors that hire us and because they just can't figure out how to do this every year. And so say, for example, you've created a testamentary trust for a child or a grandchild and you pass away unexpectedly, then whoever is your executor / trustee at that point is going to have to each year file this accounting, which is each penny in and each penny out, until that trust is over. And so if you have a child that you said, well, I'd like the money held in trust until they're 25 and your child is 8 when they pass away, that's a lot of years and a lot of money that's going to be spent doing those accountings. When we talk about a revocable trust, the reason that these are a good idea is that they are created basically right away once you sign them, and you are able to manage your assets, whether they're in this trust or not. You can allow your trustee to avoid the probate process. It allows them to avoid those costs. And it allows you also to have enhanced planning for beneficiaries, which is really nice because this will also include planning for those with special needs. And we'll talk about that in just a minute, a little bit more. Also privacy when you have a will, and if that's the only estate planning tool you have, which is fine, but it's also something that your executor is going to have to put on record with the court. And also the accountings are public. And so everybody would know what you had, what you didn't have. Now, what is the likelihood that somebody is going to go down to the courthouse and ask to see your so-and-so's estate and how that was divided? Not likely, but if you have some family issues that are sensitive and you don't want those details out there, then that's often a thing that people think about. The other thing is tax planning. And when I first started giving this presentation, really we weren't worried about doing estate tax planning because right now the estate tax exemption per person is $11.58 million. So if you and your spouse have less than 23 million in change, then your beneficiaries are not going to have to pay estate tax. However, what we as estate planning attorneys are hearing is that depending on what happens in November, and also because we now have all of the stimulus money that has come out, we've got to figure out a way to pay for that. And so people are thinking that the estate tax exemption amount may be drastically reduced. And so that is where tax planning is probably going to come back into play again. Okay. Now, we also find that more and more people are asking about an irrevocable living trust or whether they need them. We currently use them most frequently to protect assets from future creditors or to do long-term care planning. Long-term care planning with an irrevocable trust is a huge topic in and of itself. And so I can't really go into details, but if you have questions about that, I'd be happy to talk to you regarding that. This is also something we're probably going to be using more and more right now. As I said, when we're talking about the estate tax exemption, there being a good likelihood that that's going to drop at some point soon. Okay, one of the next questions is who do you name as your executor and trustee or trustee? Now, your executor is the person who is going to be taking care of your assets at your death. And so the same as a trustee, depending on if you have a trust or not. Most people will often pick a trusted family member, whether that be their spouse or their adult children. Some people don't think that their family members can handle it, or they may not have someone to handle that for them. And so they'll often pick a trusted friend, or people will pick a professional to do that. Now, we serve for a lot of our clients in this role for them, as they either don't have someone in that role or they don't trust those around them. And so we do that. Also an accountant, some financial advisors, and often banks will have trust officers that can handle that for you. Okay. Next question is when should you update your will or trust? Basically, as on the screen, when you retire, it's often a good idea to go in and talk to an attorney regarding that. If your spouse passes, if you have another child or a grandchild, if you have an illness, if there's a tax law change like we're talking about here, or if you're going to transition to an assisted living or nursing care facility. That's really important. And as I said, we don't have time really this morning to talk about long-term care planning, but I will let you know that I think that that is one of the most important discussions that you can have with an elder law attorney. And also know that there's a distinction between an elder law attorney and an estate planning attorney. We have a lot of estate planning attorneys in town that are very good. There are only a few elder law attorneys in town, and what distinguishes us is in terms of also being able to help you with Medicaid planning or asset protection planning in terms of your assets. That is a question that a lot more people are asking these days, as the average cost of a month in a skilled nursing facility is between $10,000 and $15,000 a month, depending on where you are and your level of care. And so that scares a lot of people, especially if they don't have long-term care insurance. And so oftentimes it's a good idea just to have even a consultation with an elder law attorney to see if there's anything that can be done to help protect some of those assets for your spouse. Okay, so that is my presentation. I'm happy to take any questions that you all might have, so please feel free to fire away. And like I said, there's my email address, and so if you would like to have a copy of my presentation, feel free to email me on that, or I'm happy to email this to Jeff, and he can hand that out as well.
I'll just say
that would be great.
Elder law attorney Matt Sunderland has led courses at LLI. I've taken that twice.
Matt's
and he also has a lot of clients at Sunnyside.
Yeah, Matt is also wonderful. Matt, we often share clients back and forth with Matt and Clark and Bradshaw.
I'd like to ask about, you haven't mentioned anything about power of attorney.
Sure. So that is a really good question, and that is what we often call incapacity planning. But oftentimes, incapacity planning is more important than estate planning, depending on your situation. But if you don't have what's called a power of attorney, which is it's basically a document where you are appointing someone to step into your shoes that can handle all of your financial affairs, from being able to manage your bank account, sign checks, buy or sell real estate, There's many things that can happen with that. It is a very simple document. It's usually very inexpensive. And if you don't have that, then whoever your loved ones are, if you become incapacitated and can't handle your finances, then those people will have to go to court and get guardian and conservatorship over you, which often will cost thousands of dollars for an attorney to obtain that for you. So that is a great question, and one that is a whole another topic in and of itself, but I highly recommend that you have one of those.
Also a healthcare power of attorney.
Right. And I understand that I didn't go into detail about that because I understood that that was covered in a previous presentation, but I could be wrong about that.
That was covered some last week, Laura, just the importance and significance of that.
Right. So in Virginia, we call those advanced medical directives. The first part, like you probably have heard, is the living will, which states your preference if you were to be in a persistent vegetative state or have a terminal condition where there's absolutely no hope of recovery. It's what type of care and medical interventions you would want to decide on. With a healthcare power of attorney, those are basically you're deciding if I'm not able to make these calls for myself, who's going to step in my shoes at that point.
Yeah. This is Gloria. What happens when you have a live-in situation or a paramour situation? Mm-hmm. Well, I'll be honest about it. Our son has lived with his partner for some time, and what protections or not protections are involved with that?
In terms of protections, are you meaning for the girlfriend or boyfriend or whoever it is to be able to help with these decisions, or to protect against the girlfriend or boyfriend?
Well, I guess would they be treated as a spouse?
No, they wouldn't, not unless they did all of these documents and designated them as the people that they wanted to take care of their financial affairs or make those healthcare decisions. So that's a really good question, and that's a really good reason why your son needs to have estate planning documents in place, just so that his partner would be able to make those calls, because otherwise there's no legal right for them to be involved.
Well, that's what I was afraid of. Now, can we involve her with our trust?
Absolutely. You're able to name whoever you would want, whether that be to act as a fiduciary, so as your attorney in fact, executor, trustee, or as a beneficiary. You're able to name that anyone you want in those terms.
Okay, so that would not be a problem.
No, not at all.
We like her, so there's not a problem.
That's good.
Put up with him all those years. Good for her.
Are we done?
Laura, I'm wondering if you could speak a little bit to a little bit more maybe to the group you mentioned, those with special needs, just a little bit more about how that might play out.
Yeah, absolutely. So if you have a loved one that has special needs that's receiving any kind of government assistance, it's really important that you take that into consideration in your estate planning, because you may think that you're doing a really good thing by leaving money to that person. But oftentimes what that's going to do, if you don't set it up correctly, it's going to make them ineligible for their benefits, at least for a period of time. So what we suggest, depending on who that person is to you or the level of money that you're going to be giving that person, we do special needs trusts for that. And what a special needs trust is it's a trust that's set up by someone other than the person with special needs. And it allows whoever's acting as trustee to supplement but not supplant the benefits. So for example, whoever's the trustee could pay on behalf of the person with special needs for anything that's not already covered by government benefits. And so that can be anything from therapies to a vacation to, video games, anything like that, as long as it is not supplanting that. And you just can't give money outright for the person. You can pay for it. There are other things that you can do. There's something called an ABLE account. Special needs planning in and of itself is really complicated. But just know if you have someone in your life, it's really a good idea to talk to an estate planning attorney about that and to see what options are out there so that you are able to protect their benefits and they can still get what they need as they age.
Laura, I appreciate you being with us so much. And I was just wondering if there are any resources that you recommend for starting places, maybe for those who are.
I'm sorry, you just cut out. You said starting places and I missed the last part.
Yeah, sorry, I got muted somehow. Starting places for where one might look online to start to know kind of what questions, what documents, just how to start the basic process before maybe going to a lawyer.
I don't recommend that. I will tell you most estate planning attorneys, our firm included, offer free consults for estate planning. We don't ever charge for that because we want people to be able to get the information they need and also to make sure that there is a good rapport and if you feel comfortable with the attorney. So I always recommend just going and talking to an attorney. There's no obligation and I think you'll learn a lot more that way. There's just too many websites out there and we have no control over what is said, and there's often a lot of bad information that's out there on the internet.
I'm going to ask another question, and I don't want to dominate, but I've done work in my pastoral work with couples who they've had long, healthy, wonderful relationships, and in their 70s, 80s, 90s have decided some to remarry, some not to remarry. Do you have any wisdom or commentary on that? On
whether it's a good idea to remarry or not?
Yeah, from a legal perspective. Yeah.
That's actually a good question. And oftentimes I meet with people in that scenario and they want to talk through that. I think that that's a very personal choice, but I think what people mostly want to think about is how that maybe the inheritance rights would change in terms of that. And my take on it is that getting married, if that's what you want to do, there are things that can be put in place to protect whatever you're trying to protect. So I always recommend that if you want to get married, go ahead and get married. The only reason that I would say it may not be a good idea is if one spouse may have long-term care needs that are pretty apparent, because when you're looking at long-term care, and I'm happy to just speak a little bit about Medicaid and skilled nursing and how this all will come into play. If you say, for example, you're married and a spouse becomes either afflicted with Alzheimer's or dementia, and they require care, whether that be at home or in an assisted living facility or in skilled nursing, ultimately, in order for Medicaid, which is the Medicaid that pays for long-term care, basically, if a person is married, a good deal of the assets have to be spent down in order to qualify for Medicaid to step in at some point and pay for the care. And so if you have been married for years and then either your spouse passes or there's a divorce situation and you are thinking about getting married, but either you or the one that you're thinking about getting married has some affliction like that, that's where you really probably want to go and talk to a long-term care planning elder law attorney, because we can also talk about doing some asset protection planning. But oftentimes what happens is people don't realize that implication, and they will have to spend down a good part of their assets taking care of that spouse. So that's really the only situation that I worry about.
Thank you.
Mm-hmm.
Jeff, Bill Reinhold here. I wonder if Steve wanted to say a word or two about the planning, the advanced directives or healthcare in relation to what we've heard this morning.
Sure, you'd be welcome to do that. Laura, just for information, Steve is a retired physician who presented to us last week on the medical side of things. So,
Awesome.
Yes. Can you all hear me okay?
Yes.
Okay. I guess I did particularly want to let people know, as many of us, including my wife and I, who already have advanced medical directives, that it's periodically a good idea to review them and see that they still say what you need to say given your current situation. Also, I had not previously been aware of the 5 wishes form of an advanced medical directive, and that addresses a lot of other issues besides just the nitty-gritty of a primary agent and secondary agent and of the wishes in a vegetative state. It also gives you lots of opportunities to address your thoughts about other possible medical scenarios. You can't anticipate all of them, but it's a good communication tool with family. And the Trinity Presbyterian Church has ordered 25 copies, and they should be available, I guess, to contact the church office. It's a good thing to look at, to think of possibilities, and I'd recommend that all adults have some type of advanced medical directive, even if you choose to cross out some possibilities, and everybody's situation's different. But anybody have any questions I can help with? Or Laura, let me know if I've misspoken in any way.
No, you've done a great job in terms of that. That's really important, because there are so many different decisions that need to be made outside of what I call the big one, which is what you're expressing in terms of your living will. What we do for clients, in addition to their advanced medical directive, we have a form. It's called a letter of instruction to healthcare agent, which basically it's several pages long, and it has all sorts of scenarios. And so it's kind of like a quiz checklist for you to go through and designate, if I were in this situation, this is how long I would want to receive this type of treatment. And our clients have said how helpful it is, because it's really hard for people who are in the situation where they're trying to have to make these decisions for their loved one, to know what to do. You think you would know, but when you're actually faced with that decision, oftentimes people are unable to really think clearly in terms of that.
Yeah, and it certainly is a problem if you don't have a designated agent and you have 4 children and they really don't see the issue the same way, and it can cause major problems.
Absolutely. And that's why when I am talking to clients about who to designate as their healthcare agent, oftentimes they'll say, oh, just my children. And I'll say, okay, well, let's talk a little bit more about that, because first you need to know which of your children could actually be able to make those decisions, because not all of your children probably want to or are emotionally able to do that. And also, there are those who just aren't able to get along as much as you would like to think so. And so I often tell people it is better to name one person, and if that person's not able to act, then name the next one, and so on down the list.
I totally agree. I've run into problem situations occasionally over the years when there wasn't one designated person.
Absolutely.
I'm not hearing any other questions.
Jeff,
Go ahead, Mary Lou. Go ahead.
yeah. So one cautionary thing that I would like to just add to all of that, which is what I added to my letter of instruction to my children, is that you fill out these 5 wishes. You have an ideal scenario of what you think you'd like in a given situation. But what I wanted to be very clear for them is that if that time comes and what I have requested is just not really possible, it's not, and it's simple things like, you want music played, you want to be in your own home, you want someone there to hold your hand. It may be that that's not how it works out. And I wanted my children to be very clear that I trusted them to make the right decisions at that moment, knowing that they would do what was right for me and what was right for them. When Charles's mother was ill with dementia for 10 years and was bedridden for the last 4 years of her life, and we were bound by some of her wishes that probably were not the best for her or for us. And so I think, you kind of need that phrase in there that says, when I'm writing this is what I think would be great. But if it's not the case when this actually arrives, do what you know is best for yourselves in particular and for me in the end. Just 2 cents worth there.
That's a great point.
I'll just put go
ahead, Virginia.
I'll just put an extra extension on all that we've been talking about and tell you that Dick entered hospice care this week. Mm-hmm. And I've learned a few other things about ways that folks manage his care from Sunnyside and with the help of the hospice staff. So,
thanks for sharing that with us, Virginia. It's a big change for your family. Transition time. I am conscious of the time and will share one little story because I love to tell stories. I was a healthcare proxy for a person I was designated in that role, and they had a separate estate plan set up, and I called the bank to let the trust officer know that the death had occurred, and the person was very kind and said, "Thank you. Your responsibilities as healthcare proxy are now finished, so thank you for your time and for the phone call." Very clear that one role doesn't necessarily lead to another. And so it's really important, as you've pointed out, Laura, to designate those and to be clear with people about who does what and who takes care of what. Laura, I want to thank you again so much for your time. And please, again, don't worry about your children. Those of us that have them and have had them around or love them recognize that that's life right now. So no worries.
Yeah, thank you.
I will also name that this session has been recorded and will eventually be put up on the YouTube channel, along with a recording that Virginia Bethune and I did this week around musical thanatology. And we're going to continue the conversation next week with Stephanie, moving into funeral planning and what happens next. I was designated for a different individual, the executor of their estate, and we talked through all those important features. And I said, well, I have one more question. What do you want me to do with you after you've died? And they said, oh, I didn't think about that. So Stephanie will help us with that, unpack that next piece next week. So thank you all, and I wish you God's peace, and join me again in thanking Laura.